All right, good afternoon. Thanks for tuning in today. I'm Sarah Miller. I'm the Vice President of Marketing and Strategic Communications at the Small Business Association of Michigan. And we are welcoming DeAndre Harris with Warner Norcross and Judd for today's presentation on understanding and navigating the revised independent contractor rules. A couple of quick housekeeping items. This webinar is being recorded. We'll send out a copy to everyone who is registered, and it will also be available on our website later today. The slides will also be made available to you, so feel free to take notes, but you'll get a copy of the slides with that recording. Questions, ask your questions, go ahead and use the Q&A or the chat. We will save time for Q&A at the end of the presentation. So just know that DeAndre is going to go through these 6 rules, and then we will take the Q&A at the end. Try to keep them fairly broad. We can't go into specific, super specific situations here on today's webinar, but I know DeAndre will do his best. So DeAndre Harris, thank you so much for joining us today from Warner Norcross and Judd. SBAM has a long relationship with WNJ. We appreciate you being here today to teach us more about these revised rules.
Thank you, Sarah, and I am happy to be here. As Sarah mentioned, the purpose of today's presentation is to discuss some changes that have been made at the federal level concerning the status of whether a worker is an independent contractor or an employee. As Sarah mentioned, I am an attorney, a partner with Warner Norcross and Judd in our labor and employment group. I am going to quickly pass this slide because talking about yourself is awkward and I don't enjoy doing it. Our labor and employment practice group provides clients multiple types of services within the HR sector, including issues concerning hiring and firing, discipline, etc., as well as compliance with federal and various states' labor and employment laws. So it's important for you to understand my background and the experience that I have to discuss the issues that we will be diving into today. And so with respect to the new final rule that the Department of Labor has issued, it's important before we jump into the rule, I think we should discuss why it's necessary for us to understand why this rule is being issued. And so under the FLSA, the Fair Labor Standards Act, that act covers employees only. And with respect to many labor and employment laws, the FLSA also has a definition section so that potentially covered employers can understand whether and to what extent they need to comply with the act's obligations. And that act defines employee as any individual employed by an employer. That is the Act's definition of an employee. And with respect to employment, that the Act basically states that the act of employing someone is to suffer or permit them to work. Now, as you can imagine, that definition is wholly unhelpful when understanding whether and to what extent a worker is an employee. And that's an important understanding to have because with respect to the FLSA, if you are an employee then you are entitled to the FLSA's protections, which includes earning a minimum wage, as well as earning overtime at time and a half, unless a potential exemption applies under that act. And so with respect to this definition, it's important to understand exactly whether a worker is an employee, because if so, an employer has those obligations to keep in mind when they are engaging that worker to perform services for the organization or company. And so all that to say, the concept of employment under the FLSA is very broad. And because of this broad definition, the Department of Labor has to step in to provide employers some guideposts to understand whether and to what extent the worker that the employer is engaging to perform services is in fact an employee that is entitled to the FLSA's protections. And so to provide some context about how we got here today, on January 10, 2024, the U.S. Department of Labor published its final rule, which revises the agency's guidance on this question. In doing so, the final rule also rescinds an earlier rule that was published by the Trump administration right before Trump left office in 2021. And just so that we can understand the difference here, under the Trump administration's DOL, that Department of Labor focused on primarily two factors when determining whether a worker was an employee: the nature and degree of control over the work, and the worker's opportunity for profit or loss based on initiative and investment. Now, there were other relevant factors that could be considered outside of these two core principles, but really from the Trump administration's DOL standpoint, those were the two core issues to consider when determining whether a worker was in fact an employee for purposes of the FLSA. As I mentioned, the final rule rescinds that rule and replaces it with the rule that we're going to discuss today. But just to provide some additional context, it's important to understand that this final rule, the Department of Labor, this is really the department's second attempt to replace that rule. Prior to issuing the final rule this year, the Biden administration attempted to withdraw the Trump administration's rule in May of 2021. Business groups, however, sued, and they were successfully able to convince a federal court in Texas to force the the Biden administration, to withhold or back off of rescinding the Trump administration's DOL rule. As a result, up until January, employers have been relying on that previous rule that I mentioned, where the core focus is on the nature and degree of control and the opportunity for profit or loss. It's important to note that although this rule took effect, I should say, in March of this year, the future of the rule still remains uncertain. Now, as you all may be aware, there has been a lot of litigation as it relates to many of the federal employment laws and regulations that have been developed under the Biden administration and by Congress within the last couple of years or so. And more often than not, when those rules or those laws are challenged, particularly in the federal courts within Texas or Alabama, those rules or laws often don't have a high likelihood of success. And here there has been multiple cases filed as it relates to this final rule. And although there has not been any order by any federal court to enjoin the rule from taking effect, the rule is in effect today because it went into effect in March. The future of the rule still remains uncertain. And so all that to say, you should assume that the rules that we are discussing today are the law of the land for purposes of this question. That said, it's also important to keep in mind that there is pending litigation that addresses the enforceability of this rule from a long-term standpoint. And so where did we go and where are we now? Under the new revised rule, we really take a blast to the past. And what I mean by that is the rule now is structured in a way where it mirrors, in large respects, the test that the Department of Labor relied on before the Trump administration's Department of Labor took over that agency. And so the principles that we will discuss today, depending on how long you've been in business, they may seem familiar to you, and that's likely in large part because these rules have been in effect in the past. Although one could argue that they go a bit further than what the Obama administration's DOL, for example, went as it relates to the scope of the rule. And so the rule that we're discussing today is the economic reality test. And what that test provides under the final rule is a worker is not an independent contractor if they are, as a matter of economic reality, economically dependent on the employer or the potential employer, I should say, for work. And in order to make this determination about an employee's or a potential employee's economic dependence, the Department of Labor is going to review 6 factors. Those factors include the opportunity for profit or loss, depending on managerial skill, investments by the worker and the potential employer into the work, the degree of performance of the work relationship, the nature and degree of control, the extent to which work performed is an integral or a critical part of the potential employer's business operations, as well as the skill and initiative that the worker relies on when performing the work for the potential employer. And here it's important to note, no one of these factors controls this assessment. In other words, this is a totality of the circumstances review and determination, and whether and to what extent one worker should be classified as an independent contractor or an employee is going to be super specific to that potential employee's working conditions. All that to say, you may have competitors or counterparts in other or in the same industry as you, and they also employ a specific position or they engage a specific position as a contractor. I don't think it's a good idea to rely on that employer's classification of that worker if you have the same position, because ultimately titles alone aren't going to be enough to make the determination here. And so, for example, you may have a security guard who is classified as an employee, and your counterpart may also classify a security guard as a contractor. I think it's a bad business practice to assume that because that organization classifies their security guards as a contractor, that you can go ahead and make that same classification. Ultimately, this is a totality of the circumstances assessment, and so it's important to keep that in mind before making decisions based on what competitors, colleagues, other organizations, and companies do. All right, before we jump into the rule, it's also important to keep in mind that what we're discussing today is for purposes of understanding a worker's classification under the Fair Labor Standards Act only. There are other laws and other regulations that address this same question as to whether a worker is in fact an independent contractor or an employee. And those bodies or those laws have different tests. And so, for example, the Internal Revenue Code, that the IRS also has to make a determination about whether and to what extent a worker is in fact an employee or contractor. The IRS, however, does not rely on the framework that we are going to discuss today. Instead, the IRS takes a more common law, and what I mean by common law is essentially standards that have been created by courts to determine the nature and degree of control over that the potential employer may have over the employee. And so that's considering the party's behavior, their financial relationship, and the type of their relationship. Likewise, the National Labor Relations Act, which provides non-managerial employees the right to engage in unionizing and also engage in protected concerted activities, such as discussing their wages, hours, and terms and conditions of employment. The National Labor Relations Board, which is the entity that oversees enforcement of the act, also has to make a decision as to whether an employee or worker, I should say, is in fact an employee who is entitled to the NLRA's protections, or a contractor and as a result is not entitled to those protections. You may be familiar with the National Labor Relations Board and how essentially the pendulum and the principles that the board relies on swings with a presidential administration. And so because we have a board that is now more employee friendly in terms of the principles that they are espousing through their decisions, the board has recently decided within the last year that they are going to take a view of looking at this independent business analysis for purposes of making this determination. And so that assessment does mirror the rule, that the final rule and the factors that we're going to discuss today. That said, that is a matter of essentially a decision, a court opinion or a quasi-court opinion, I should say, and not necessarily the same test that we're looking at today. And then finally, states have the ability to create and enact statutes that address this question as well. And there's been an increasing trend with certain states to adopt what is commonly referred to as the ABC test. And so, for example, California and New Jersey, I believe Illinois may also have that test now. And under that test, a worker is considered an employee and not an independent contractor unless the hiring entity or the potential employer satisfies three conditions, all three conditions, and those are the worker must be completely free from control and direction of the entity. The worker must perform work that is outside the usual course of the hiring entity's business. And this is the last one. The worker is customarily engaged in an independently established trade, occupation, or business of the same nature as that involved in the potential employer's businesses. As you can imagine, that is probably the most employee-friendly standard there is, at least within the United States. For purposes of Michigan, we do not have the ABC test. In Michigan, we tend to rely more on the common law. But all that to say, it's important to keep this in mind when we're going through these rules here. The assessment that is being made based on these rules is whether a worker is an employee for FLSA purposes only. And so when you're making these classifications, this is one only, I should say, this is but one test that you need to be aware of. There are multiple out there depending on how that classification impacts, for example, taxes or an employee's rights under the National Labor Relations Act. And so let's discuss the rules in further detail. And the way that I think this will be best helpful is we'll go through what the rules provide and then also go through some examples with each factor. And as Sarah mentioned at the end of this presentation, I'm happy to answer any questions that you may have as it relates to some of these factors or all of the factors and how they overlap. You will see as we go through these factors that there is some substantial overlap between one factor and the next. And so just keep that in mind. With respect to factor one, as I mentioned, the first factor to consider is whether there is an opportunity for profit or loss depending on managerial skill. Now, that factor can be assessed through asking a series of questions. The first one being whether the worker determines or can meaningfully negotiate the charge or pay for the work produced. And I think that is pretty self-explanatory. Then also whether the worker accepts or declines jobs or chooses the order and or time in which the jobs are performed. Whether the worker engages in marketing, advertising, or other efforts to expand their business or secure more work. And then finally, whether the worker makes decisions to hire others, purchase materials and equipment, and or rent space. Now, here, with respect to these factors, one element where it's clear that the Department of Labor now is looking to make this test a bit more stringent for employers. The final rule makes clear that if a worker has no opportunity for loss or profit, then this factor suggests that the worker is an employee. Now, that is consistent with the prior test, the rule that was replaced with the most recent final rule. That said, the final rule also goes on to say that some decisions by a worker that can affect the amount of pay that the worker receives, such as working additional hours when the employee or the worker is paid at a fixed rate or based on an hourly rate, that worker's decision to merely work more hours based on that pay structure, that is not going to be indicative of the worker being an independent contractor. I think that this is the first deviation that we see from the prior rule because generally speaking, many employers have taken the position that if we provide the employee or the worker, I should say, the contractor, the opportunity or the choice to pick up shifts or deny shifts, then that is going to be an element that is indicative of the worker being a contractor. And what the Department of Labor has said in response to this position is it depends on how the worker is paid. If the contractor is paid by hour, and essentially the contractor is then forced to work, let's say 40 hours a week, then that pay structure and the contractor's decisions to achieve that amount of pay is going to be more indicative of an employment relationship as opposed to a contractor relationship because the contractor is losing out on the ability to go out and provide those same services to other organizations or companies. And so let's just walk through this factor through an example. Factor one here, the example is a worker for a landscaping company performs assignments only as decided by the company for its corporate clients. The worker does not independently choose assignments, ask for additional work from other clients, advertise the landscaping service, or try to reduce costs. The worker regularly agrees to work additional hours to earn more money. In this example, the worker does not exercise managerial skill that affects their profit or loss. And managerial skill is ultimately what the Department of Labor is looking for. So let's turn this example on its head. Let's say the worker provides landscaping services directly to corporate clients. The worker produces their own advertising, negotiates contracts, decides which jobs to perform and when to perform them, and also decides when and whether to hire additional work, or excuse me, additional helpers to assist with managing the workload. Under that sort of framework, the worker is exercising managerial skill that affects their opportunity for profit or loss. And those facts are going to be indicative of an independent contractor relationship as opposed to that of an employment relationship. Right, going to the next factor here, the factor two relates to the investments by the worker and the potential employer. And again, as we go through this, we'll see the goalpost is being moved under this new framework as opposed to what we are used to seeing when we're going through this analysis. And so this factor relates to whether the worker provides investments into the operation that are capital or entrepreneurial in nature. This is new language under this final rule. And what I mean by that is this: cost to a worker of tools or for a specific job and cost that the employer imposes on the worker. Traditionally, or I should say under the prior rule, if an employer or an organization required an independent contractor to cover the costs associated with the materials or tools or equipment necessary to perform the job, that would be indicative of a contractual relationship or an independent contractor relationship. The Department of Labor, however, has stated that that is not enough to demonstrate that sort of relationship because that sort of cost, those sorts of costs are not capital or entrepreneurial investments. And generally speaking, capital or entrepreneurial investments support an independent business and serve a business-like function, such as increasing the worker's ability to do different types of or more work, reducing costs, or extending market reach. And ultimately, what the Department of Labor says is take into account the types of costs that the potential employer has in order to run its operations. The Department of Labor is looking for those same types of costs when making this determination as about the contractor. And so when an employer has to run an operation, the employer spends funds on marketing, spends funds on insurance, perhaps workers' compensation, things of that nature. And the Department of Labor is looking for those same types of investments, even if it's on a smaller scale from the contractor. And absent those sort of investments, the costs associated with tools or equipment to perform a job are not going to be indicative of an independent contractor relationship. And we have an example here as well. So a graphic designer occasionally completes specialty design projects for a commercial design firm. The graphic designer purchases their own design software, their computers, drafting tools, and also rents their own space. I think it's fair to say as well with this example that the graphic designer may be operating as an entity as opposed to a sole proprietor. In other words, we may be discussing an LLC, for example, here, as opposed to an individual in their individual capacity. The graphic designer also spends money to market their services. These types of investments support an independent business and are capital in nature. They allow the worker to do more work and find new clients. And as a result, these circumstances would be indicative of an independent contractor relationship with the commercial design firm. Now, with all of these examples, you can flip the circumstances on their head and see how the assessment will drastically change. So for example, let's say the graphic designer provides design services to the same commercial design firm, but the firm provides the software, the computer, the office space, and all of the equipment necessary to perform the work. And the firm also invests in the marketing and the advertising in order to provide the clients for the designer to perform the work. Under these circumstances, the designer is more than likely going to be classified, or this factor would be indicative of an employee as opposed to an independent contractor. And that's true even if the designer on occasion decides to use the designer's own tools for purposes of performing the work for the commercial design firm. Absent those sort of capital and entrepreneurial like investments into the workers' services, this factor would not be indicative of an employment relationship, according to the Department of Labor. And then finally, with respect to factor three, the degree of performance of the work relationship. Here, it's important for me to just put a pin in a later slide. We will address some common, what I consider red flags when looking at classification issues and some common themes that we see as counselors with respect to this issue. But this is one of them that I think is worth noting. And before we get there, let's just talk about the rule. Under this factor, the degree of permanence of the work relationship essentially states that to the extent that the work relationship is indefinite, continuous, or exclusive, then that is going to be indicative of an employment relationship. However, if the work relationship is definite, non-exclusive, and either project-based or sporadic, then that is going to be indicative of a independent contractor relationship. There's also important to discuss some of the nuances as it relates to just the flow of work, because there's certainly, depending on, let's say, if you are in the agricultural industry, then it's unreasonable to assume that work would not be seasonal or temporary in nature. And even though that's the truth, the Department of Labor has basically stated that seasonal or temporary work by in and of itself is not indicative of an independent contractor relationship. And so although the work may be regularly occurring fixed periods, if the only reason it is sporadic or broken up into projects is because it is seasonal or temporary in nature, then that industry is not, because you are operating within that sort of industry, that's not going to be enough to demonstrate that the work is sporadic enough to form an independent contractor relationship. This last bullet here also addresses that. When we're talking about operational characteristics that are unique or intrinsic to a particular business or industry, then this factor would not necessarily indicate independent contractor status unless the worker is exercising their own independent business initiative. And we'll talk about that further through this example. What I was going to say, though, as it relates to some of those themes that we see on our end when we get questions about whether someone is a contractor or not, a lot of times we are provided with independent contractor agreements that do have fixed periods or fixed terms. However, the agreement renews automatically, or the agreement has either been ignored after its expiration term and the parties have continued in that contractor relationship. Under those circumstances, the evidence of the independent contractor agreement and the specific fixed term provision loses a lot of weight when making this decision or making this determination about the permanence of the work relationship. And so all that to say, it's important to keep in mind that if you truly do have a fixed term agreement with your contractors, to the extent that you make a pattern of renewing that agreement, ultimately, and I've seen this through wage and hour audits with the Department of Labor, the Department of Labor could very well decide, despite what the agreement states, there is a level of permanence here that suggests that the work relationship is indefinite or continuous in nature. All right, so with respect to the factor three example, let's say you have a cook who has prepared meals for an entertainment venue, a wedding venue, for example, and the cook has prepared these meals for several years. The cook prepares meals as decided by the venue, depending on the size and specifics of the event. The cook only prepares food for the entertainment venue, which has regularly scheduled events each week. The relationship between the cook and the venue is likely going to be characterized by one of a continuous or indefinite uh, nature because of these sort of circumstances. Now, again, we can flip this example on its head, and let's say that the cook basically prepares meals for multiple entertainment venues and is a vendor with, you know, 3 or 4 venues in town. And depending on the cook's availability, the cook has the ability or to just decide that because of his workload or her workload, um, that they don't have time to cater to a specific event with a specific venue. Based on that sort of decision making and the cook's ability to take projects at a sporadic level or on a sporadic basis, based in part on the cook's availability and the cook's non-exclusive working relationship with the venue, those circumstances are going to be are going to be more indicative of a contractual or an independent contractor relationship as opposed to an employment relationship. Right. Factor four, the nature and degree of control. I think that this is the factor that most individuals are familiar with when we're talking about this assessment as to whether someone is an employee or not. That said, excuse me, the final rule goes a step further than what we are commonly used to with respect to this factor. And what I mean by that is the Department of Labor is not only considering actual control over these things, such as scheduling, the supervision of work, the worker's ability to work with others, such as non-competes and whether those exist, or actual control over the performance of the work, such as the ability to discipline an employee, and then actual control over the rates and the economics of the relationship. In addition to considering actual control, the Department of Labor is also going to consider reserved control. And what I mean by that is to the extent you have an agreement with an independent contractor that states that you reserve the right to modify the schedule, subject the independent contractor to periodic performance reviews, um, meet with the contractor on at a regularly set date or time to assess the performance of the work. As long as you reserve that control, even if you don't actually carry out any of those steps, this factor alone could be satisfied or could weigh in favor of an employment relationship based on the reserved control that you have with the potential with a worker. That is a step further than what we've seen in the past. And so, you know, as I stated from the outset, I think that while this framework is a blast from the past, it does go a bit further than what we've seen historically as it relates to some of these same principles. Um, that said, it's also important to keep in mind, according to the DOL, that actions taken by a potential employer for the sole purpose of complying with the specific applicable law or regulation, that is not going to be indicative of control for purposes of this assessment. And so, to the extent you are in an industry where, for example, drug testing is required by federal law, if you subject the or the potential worker, employee, I should say, to a drug test in order to satisfy your obligations by law, then that sort of control is not going to be indicative of an employment relationship. And so we have an example here. A registered nurse provides nursing care for Alpha House, which is a nursing home. The nursing home sets the work schedule with input from staff regarding their preferences, and then ultimately determines those staff assignments. Alpha House's policies prohibit nurses from working for other nursing homes while employed with Alpha House. And the reason that they have this policy in place is to protect their residents. In addition, the nursing staff are supervised by regular check ins with their managers, but nurses generally perform their work without direct supervision. Under these circumstances, although it's true that Alpha House does not closely supervise the nurses, and the nurses can also express preferences for their schedule, Alpha House ultimately maintains control over when and where a nurse can work and whether a nurse can work for another nursing home. And so these facts are going to be indicative of an employment relationship. Now, again, with all of these examples, you can flip them on their head and see where the facts truly do matter. Let's say the same registered nurse provides specialty movement therapy to residents at Beta House, and the nurse maintains a website where the nurse holds the nurse's services out to the public uh, to contract with, and Beta House contracts the nurse, and ultimately the nurse works directly with the Beta House's residents to establish a schedule without oversight by Beta House. And as it relates to the services provided to the residents, the nurse's website already dictates what the rate of those services would be. Under those circumstances, Beta House likely is not going to be an employer of the nurse because of the nurse's ability to maintain this level of control over how the services are performed, the rate by which they are performed, and ultimately who the services are performed for. Now, let's just add one wrinkle to, this counter example. Let's assume, for purposes of understanding that Beta House is a nursing facility, that the nursing home is required by law to have all employees and contractors undergo a background check before the contractors can interface with residents. To the extent that Beta House requires this nurse to undergo a background check, that level of control is going to be solely for the purpose of complying with applicable federal or state or local rules, regulations, or laws. And so that in and of itself is not going to be indicative of an employment relationship when the overwhelming evidence suggests that this nurse has the ability to control the nature and the degree of the work that the nurse performs. And then with respect to our last two factors here, factor five is essentially whether the work performed by the worker is critical, necessary, or central to the potential employer's business operations. And I think, with respect to an example, let's consider, for example, you are a fashion designer or a interior designer firm, and this interior designer, the company contracts with an accountant for the purposes of maintaining its books. All that accountant performs a role that is helpful to understand the financial status and condition of the interior designer firm's um, financial structure. The accountant isn't performing the work that is critical or integral to the interior designer's firm. In other words, the accountant is not picking out countertops and things of that nature, and so therefore the accountant would not be performing work that's integral to the business operations. And then lastly, skill and initiative. And here it's important to understand that, well, before I say that, skill and initiative essentially relates to whether the worker uses specialized skills to contribute to business-like initiatives. And it's important to understand that bringing such skills to the work relationship is not enough to indicate an independent contractor relationship. And so what I mean by that is perhaps the worker has a resume or a website that provides certain credentials, unless the worker is actually relying on those credentials and those certificates and the background experience that the worker has gained to perform the work that it will be performing for the potential employer, then merely having those credentials is not going to be enough to satisfy this factor. Here, it's important to understand that titles can be a red herring when assessing this factor in and of itself. And I'll give you an example. I represented a client that was undergoing a wage and hour audit, and the client, going back to security guards, the client classified all of its security guards as um, contractors. And the rationale, or part of the rationale behind that classification was, well, security guards perform, specialized work. They are able to provide certain safety trainings or certain safety to the workforce through the type of work that they do and through the nature of what a security guard in and of itself does, that's specialized and skilled enough to suggest that these individuals are properly classified as contractors. What happened when we went through this audit, though, is we learned that although these individuals, their titles were security guards, ultimately the actual functions of their work were watching surveillance cameras at a desk. And to the extent they made the decision that security was necessary, contacting local law enforcement. And what the Department of Labor said was these are not security guards and they don't have the skills or the specialties associated with security guards. Rather, they are front desk receptionists. And because they are performing the work of front desk receptionist, which does not require any sort of training beyond what the employer trains them on, this factor was not indicative of an independent contractor relationship. Instead, the security guards, as receptionists, were actually employees of the organization. And so here it's important to make sure that you understand exactly what the work being performed is, as opposed to the titles of the individuals that are performing the work. Now, as I mentioned, those are the rules, and I thought it would be helpful that we just discuss some common misclassification red flags that we see in light of these principles. And this is a non-exhaustive list. I should be clear about that, but they do happen frequently enough where it's important for you to be on guard and to consider whether or not this applies to your organization. And so number one red flag is where the independent contractor is performing the same type of work as employees. To the extent that this is the case, you should be considering whether or not they actually are subjected to the same level of control, and also if there are any other extenuating circumstances that suggest or that sets the independent contractor apart from the work that the employees are performed. But generally speaking, absent any other, nuances or unique circumstances, if an independent contractor is performing the same work as employees, more than likely the Department of Labor or a reviewing court is going to call into question the classification of that independent contractor. Same thing as it relates to, and this also bleeds into the second bullet point here, which is independent contractors who once were an employee. We often get situations where someone may be considering retirement, but they don't want to just completely, break free from the organization. And so what they suggest and what the employer agrees to is, why don't we bring you on as an independent contractor where you're performing the same work? Well, that sort of those circumstances are going to be viewed as suspect unless we can demonstrate again that this individual is not only performing the same work, but perhaps is going out into the industry and trying to market their services to other organizations as well. Absent those additional circumstances where an independent contractor was once an employee and ultimately is just reclassified either at the request of the employee or by mutual agreement between the employee and the employer, that sort of framework is going to be viewed as suspect, and that raises alarm bells in our when we're going through these sort of assessments. Same thing as it relates to a workforce that is primarily made up of independent contractors. This highly suggests that the independent contractors are performing work that is integral to the organization. And so therefore, more than likely, there's a chance of misclassification there. And then finally, I don't want to go through all of these, but I think it's worth noting the same sort of assessment can be applied to an independent contractor who is either supervising employees or is otherwise maintaining a key leadership position. That sort of placement is going to suggest that the supervisor is again performing work that is integral to the organization or is otherwise critical to the organization. And so that is going to be a factor that is indicative of an independent contractor relationship. I want to make sure that we have time to get into some Q&A here. And so what I will do is I'll just go through the liability associated with misclassification, because as you can imagine, it is a bit of a cascading effect. And so from the FLSA standpoint, if the Department of Labor determines that an employee has been misclassified as an independent contractor, the employer is going to be subject to providing not only unpaid wages. For example, if the contractor was supposed to be classified as a non-exempt employee entitled to overtime, but in addition to unpaid wages, the FLSA also authorizes the Department of Labor to seek liquidated damages in an amount that is equal to those unpaid wages. And the period that we're looking at is generally 2 years, unless the Department of Labor can establish that the employer has been willfully violating the FLSA, in which case the back pay period extends to 3 years. And then finally, there are also civil penalties associated with noncompliance as well. Um, Most often in these cases, unless the circumstances really are worth fighting for, employers tend to work out some sort of settlement agreement with the Department of Labor. But in the event that that does not happen, the FLSA also authorizes the Department of Labor to seek attorney's fees either on the employee's behalf, or the employee to seek attorney's fees if the employee brings the case without the Department of Labor. And then beyond the FLSA, it's also important to recognize that, again, this question of whether a worker is an employee or a contractor really does touch on various areas of law. So, for example, in Michigan, if you misclassify an employee, then more than likely you have not been paying unemployment taxes on that worker. And in Michigan, the state of Michigan will seek the recovery of those taxes. Likewise, as it relates to workers' compensation, all Michigan employers are required to provide their employees some form of workers' comp. And if you fail to do that, then you lose out on the benefit of the workers' compensation statute, which is essentially the exclusive remedy provision. And so what that means is, in Michigan, if a Michigan employer has workers' compensation and an employee suffers a work-related injury, then the employee is going to be precluded from bringing a lawsuit against the employer, unless the employee can establish, which is a high bar, that the employer has engaged in an intentional tort to cause the harm that the employee suffered. If you don't have workers' compensation and you should have provided workers' compensation to an employee, then you lose out on the protection of that exclusive remedy provision, and an employee would be able to go after an employer for, let's say, pain and suffering related to a work-related injury, even if they can't establish that the alleged injury was due to intentional harm. And then finally, you also need to worry about unpaid benefits. So, for example, in Michigan, if you are covered by the Paid Medical Leave Act, you have to provide certain employees with up to 40 hours of paid medical leave. If you are not providing that to workers because of misclassification, then there's going to be an issue there. And then likewise, it's also important to consider just the I would say tangential effect as it relates to misclassification. As many of you may know, when we're talking about anti-discrimination laws, most often than not, your coverage under those laws depends on how many employees you have. Now, in New York and other states, they also include contractors, but in Michigan, for example, if you have less than 50 employees, then you are not covered by the Paid Medical Leave Act. That said, if your employee count is because of your misclassification of certain workers, and you ultimately are supposed to be covered by the act, then you have to again deal with the ramifications and the consequences of not complying with certain laws that you otherwise would have been covered by had you correctly classified your workers. And so this is a cascading effect. We've discussed the FLSA, but it's important to recognize that misclassification goes well beyond the Fair Labor Standards Act. And with that, I will turn it over to Sarah, and I'm happy to answer any questions that you may have.
Great, thank you. That was a very thorough explanation. We did get a few questions that came in while you were speaking. The first question is, are gig economy jobs versus knowledge-based professions recognized while reviewing these factors?
That's a great question, and I can say that from the standpoint of from the Department of Labor standpoint, there is no industry exceptions. For example, considering DoorDash or Lyft or Uber Eats, there's no separate sort of framework for those industries that we have commonly recognized to be gig sort of jobs. And so those industries are going to be subjected to this same final rule and the same factors as those knowledge-based professions or non-gig economy jobs. And so ultimately the answer is no, there's no distinction between industries when we're looking at these final rules.
All right, this one is about someone who employs a cleaner. They have their cleaner that comes into the office on weekends, and they have her as a contractor because she chooses when she comes in, and she has other jobs and advertises her cleaning business. But the business owner provides supplies and the relationship is ongoing. So would this be an instance where she would need to be reclassified?
And this gets into what we said at the outset of this conversation. This is such a fact-specific inquiry that it would be inappropriate for me to say, based on just these factors, that yes, this person is or is not misclassified. I will say, though, that with respect to the factors that have been outlined, those are indicative of an independent contractor relationship. If she is performing her work to multiple I'm assuming this may be an office space. Let's assume it's an office space. This person, she's performing cleaning services as opposed to whatever the nature of the business operations are for the office. And so, with respect to the integral or critical function of her position, of the work that she's doing, that would be indicative of an independent contractor. The fact that she works for other organizations and provides these same services to other offices, perhaps, that's also indicative of an independent contractor as well. As it relates to, the tools and equipment, I would say, generally speaking, and Warner Norcross and Judd, we have a cleaning company. I don't know that providing her a mop, for example, or providing her a vacuum is going to undercut those other factors that we've discussed that are weighing in favor of the employer. But ultimately, it's such a fact-specific inquiry that we'd have to have an individual conversation.
Sure, that's fair. That's fair. Are single member LLCs considered independent contractors like individuals are?
So this is where, and I sort of alluded to this during one of the examples, but I think as a best practice, contracting with an LLC as opposed to an individual in their individual capacity is a good practice, and it is good evidence to establish a true independent contractor relationship, because a single member LLC, assuming that the single member is engaging in those business like activities that we discussed, advertising, negotiating rates, those sort of activities and deciding whether and to what extent to hire additional workers in order to secure more or different types of work. Assuming that that LLC is engaging in those business-like activities and can also demonstrate that they are putting the same types of investment into their operations as the employer or the organization for whom the LLC is performing services, I think that an LLC is more likely than not to be viewed as an independent contractor. But when we're talking about individuals who, in many cases, are not providing those sort of investments into the work that they're performing, um, individuals, I would say, almost more often than not, are going to be viewed as misclassified unless they can show that they truly are operating in a business-like manner.
All right, another question. This is kind of similar to the example you shared about a person who may, be in semi-retirement. But what if a former intern wants to become an independent contractor? Would there be some issues there?
If a former intern wants to become an independent contractor, I would say the number one question that I have is there a specialized skill or knowledge that the intern is bringing to the position? And also, again, we have to consider those other factors as well. is this intern working exclusively for us, or is this intern providing and marketing themselves as a business professional that is able to perform services to other organizations as well?
All right, and the last question I think you've answered, this was kind of like, what are some resolutions? And I think this person asks, is it hire as an employee, get an independent person to start an LLC, or no longer engage with the person? Are there other resolutions? I feel like you've probably covered that, but any other advice?
I think ultimately we have to go through sort of that checklist that we went through as far as those red flags. I certainly don't want to suggest that you have to make all of your independent contractors LLCs, because ultimately what truly matters is the LLC operating in a manner that is consistent with what we expect of business operations. If you have, Joe Schmo go and register as Joe Schmo LLC, but Joe doesn't actually do the work of a business, I don't think that that protects an organization from the scrutiny by the Department of Labor. But ultimately, I think that it's important to consider that when we're talking about independent contractors, the classic example that HR professionals provide is, if you are an office and you hire the plumber to come fix your toilets, more often than not, the plumber is going to be an independent contractor, because the plumber has a business, and you are but one toilet that he fixes among other toilets out there. And that's the sort of um, I think, perspective that employers need to have when they are considering bringing on independent contractors. Is this someone that we are truly expecting to provide us a service, in addition to providing services to other individuals and other organizations? And also, is this going to be project based and sporadic enough where we're not developing a continuous relationship? And if so, then perhaps we are in good ground. But if this is someone who is more likely than not going to be working exclusively for us, and the work that they do is so closely tied to, our mission, vision, and values, under those circumstances, I think employers are going to have, some risky, uh, some exposure to misclassification.
All right, do we have time for one final question?
I think so.
Okay, so is it possible that individuals performing essentially the same work could have different classifications? For example, one is doing work for other clients, but another is more dependent on us for the majority or all of their work.
I would say it is possible, but I think that those factors should the most the direct concern that I have with an employee and an independent contractor doing the same type of work, more often than not, the employee may be performing work that is critical or integral to the organization. Otherwise, we wouldn't be employing or maintaining that position, right? And so if an independent contractor is doing that same work, then certainly the Department of Labor is going to argue, well, this is work that is integral or critical to the organization. Now, that said, this person is right. There are other factors that we could use to overcome this factor, meaning perhaps the contractor is performing the same services to other employers, and we give the contractor the ability to decide whether and to what extent to accept shifts. I also have to be clear, as we had mentioned during that factor one slide, even if a contractor has that ability, if they're paid, by an hourly rate, that in and of itself is not going to be indicative of that opportunity for loss of profit. But yes, there are other circumstances that could help an employer in the defense of that contractor being misclassified if the Department of Labor scrutinizes the fact that they're performing the same work as the employee. But ultimately, the circumstances basically need to be checking all of the boxes under this final rule.
All right, clearly this is an issue that's very complicated with a lot of nuance. We appreciate you bringing your insight to us and to our members today, DeAndre. Thank you everybody for tuning in. As I mentioned at the start of the webinar, we will be providing the recording and the slides, so look for that in your inbox this afternoon. DeAndre, again, thank you so much for being with us today. We truly appreciate your expertise.
It's my pleasure. Take care, everyone.
All right, have a great afternoon.
Take care.